Recently, much has been said about the timing of the next general elections by both political parties. There has also been a call from the opposition Antigua Labour Party for businesses to shut down as a means of forcing the Prime Minister to fix a date for the holding of elections. On the radio call-in programs, members of the public have weighed in with their views and opinions. I recognize that in the world of politics, it is all about perception. But against that background of frenzied talk, I, as Attorney General, wish now to address you on the law and the facts, which hopefully will inform your opinions and guide your actions. Part 3 of the Antigua and Barbuda Constitution is headed, and I quote, "Summoning, Prorogation, and Dissolution of Parliament," unquote. And the sections which follow prescribe the timing for these events. Whilst two of the terms, summoning and dissolution, are explanatory, prorogation occurs at the end of a parliamentary session, usually a year, and precedes the delivery of the throne speech by the Governor-General, which opens the new session of Parliament, and the delivery of the budget by the Minister of Finance, which speaks to government's proposed revenue and expenditure for the ensuing year. Section 60, subsection 1 of the Constitution provides as follows, and I quote, "Subject to the provisions of subsection 5 of this section, the Governor-General, acting in accordance with the advice of the Prime Minister, may at any time prorogue or dissolve Parliament," unquote. What does subsection 5 say? I quote, "The Governor-General, in his discretion, may dissolve Parliament if the majority of all the members of the House pass a resolution that they have no confidence in the government, and the Prime Minister does not, within 7 days of the passing of that resolution, either resign from his office or advise a dissolution of Parliament," unquote. It is abundantly clear, therefore, pellucid, some would say, that the dissolution of Parliament lies squarely in the hands and at the discretion of the Prime Minister, except where he fails to resign from his office within 7 days of Parliament passing a vote of no confidence in his government. The next obvious question is this: is there any limit placed on the Prime Minister's discretion? The answer to that question is provided in section 60, subsection 2 of the Constitution. And again I quote, "Subject to the provisions of subsection 3 of this section, Parliament, unless sooner dissolved, shall continue for 5 years from the date of its first sitting after any dissolution, and shall then stand dissolved," end of quote. Dissolution in this instance is automatic once the time limit has been reached. But I ask you to note that the 5 years does not begin to run until the first sitting of Parliament following an election, not from the date of the last election, and not from the date of the swearing in of the Prime Minister by the Governor-General. Subsection 3 of section 60, referred to, provides for the extension of the 5-year period when Her Majesty is at war, but only for 12 months at a time and for a maximum of 5 years. Although we are an independent nation, Her Majesty the Queen is our head of state and is represented by the Governor-General, hence the deference that is paid to Her Majesty. The next logical question is this: Parliament having been dissolved, when must elections be held? Again, the Constitution, which is our supreme law, provides the answer in section 61, subsection 1. and I quote, "A general election of members of the House shall be held at such time within 3 months after every dissolution of Parliament, as the Governor General, acting in accordance with the advice of the Prime Minister, shall appoint." Unquote. Again, the election date, you will note, is solely the Prime Minister's call. But he must make that call within 3 months of the dissolution of Parliament. It is of some interest to note the dates of the last 7 general elections, and you may wish to record those for reference purposes. In 1980, Parliament was dissolved on the 5th of April, and election was held on the 24th of April. In 1984, Parliament was dissolved on the 29th of March, and elections were held on the 17th of April, while the first meeting of Parliament after elections was on the 20th of March, 1989. In 1994, Parliament was dissolved on the 18th of February. Elections were held on the 8th of March, and the first meeting of Parliament was the 21st of March. In 1999, Parliament was dissolved on the 19th of February. Elections were held on the 9th of March, and the first meeting of Parliament was on the 22nd of March. In 2004, Parliament was dissolved on the 26th of February. Elections were held on the 23rd of March, and the first meeting of Parliament was the 29th of March. In 2009, Parliament was dissolved on the 9th of February. Elections were held on the 12th of March, and the first meeting of Parliament was the 27th of April. You will have noted that apart from the 1984 elections, which were held in the 4th year of the parliamentary term, all subsequent elections were held in the 5th year, and our 5 most recent consecutive elections were held in the month of March. But that does not create a constitutional convention. Conventions are informal rules or practices which over a long period develop out of the practical realities of the day and may modify strict law. In the words of one writer, they provide the flesh which clothe the dry bones of the law. The law in this case, however, is abundantly clear, and a preference by successive prime ministers to call elections in the 3rd month of the 5th year of their term of office cannot be considered as establishing a binding practice. The first parliamentary meeting after the 2009 elections, having been held on the 27th of April 2009, the automatic dissolution of this current parliament will not occur until the 26th day of April 2014, which is the 5th anniversary of Parliament's first sitting. Unless, of course, the Prime Minister advises the Governor General to dissolve Parliament sooner. And in any event, the Prime Minister has, by constitutional law, 3 months after the date of any dissolution to call elections. It has been the practice that the Governor General issues the writ of elections addressed to the returning officer for each constituency within a day of the dissolution of Parliament. And general elections are, by law, to be held not less than 21 and not more than 28 clear days after the day specified for the nomination of candidates. Now, it is common knowledge that the leader of the opposition has appealed the High Court decisions which found in favor of the government in respect of his legal challenge to the Constituency Boundaries Commission's report and the re-registration exercise by the Electoral Commission. You may also recall that the report was approved by Parliament, but a stay was, by consent of the parties, imposed by the court against the report being forwarded to the Governor General for implementation as is required by the Constitution. The Court of Appeal has heard both appeals, one in St. Kitts and the other in St. Lucia, as a matter of urgency and at the request and on the application of the Leader of the Opposition. Both decisions are pending, and it would, in my opinion, be foolhardy to set a date for general elections before the two decisions are delivered. The outcome of these two decisions will determine whether the present constituency boundaries should be altered or not, and also whether the re-registration list of voters should be used during the elections. If a date for elections is fixed now, and the court decisions are delivered before the election date, depending on the outcome, this may create serious constitutional issues and may cause havoc or serious disruption to the election process, with possible subsequent legal challenges and uncertainties for stable governance. Any responsible person can see the wisdom in awaiting the decisions of the Court of Appeal. And in any event, the appeals were not filed by the government. Can we now simply ignore the fact that both appeals have already been heard and that the justices of appeal are now writing their judgments for delivery? What would that say for our respect for the judiciary, who are to stay independent of the legislative and executive arms of government and are charged with interpreting our Constitution and the laws of the land, and whose judgments are binding and effective to all intent and purposes unless and until the decisions are appealed to the Privy Council? One thing is very clear. The decision of the Court of Appeal in these two cases will have to be implemented in as much as time will not permit an appeal to the Privy Council. Allow me to deviate a bit and to add here that while any judgment of a court can be criticized, and legal scholars do so all the time, one is not allowed to arbitrarily question the personal integrity or the moral principles of a judge, inasmuch as this may undermine the administration of justice. Contempt of court proceedings may be filed against persons who act irresponsibly. I have, citizens and residents of Antigua and Barbuda, sought to give the legal perspective on the issues. A day in the politics can seem like a lifetime, Sir Winston Churchill, former Prime Minister of England, once said. And today more than ever, we recognize that politics is more about public perception and one party seeking an advantage over the other. This is called political strategy. But there comes a time when good sense should be allowed to prevail, particularly where it is in the national interest and for the common good of our institutions. The ultimate decision is yours, my dear countrymen, and I trust that I have provided sufficient information for your mature deliberations and reasonable considerations. I thank you for your attention. God bless.